Good morning. Are you Almeida Miles? And Ms. Miles was previously in court, entered a plea of guilty in cause number 24, DCCR 2330, to tampering with physical evidence. I received the pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections? In addition to this pre-sentence report, I've also received and reviewed a number of jail incident reports. Has everyone had an opportunity to review those? And you're 19? Why haven't you been acting right in jail?
Most of the reports are like true. One time I did not cover my face on the other side because I was asleep and she didn't wake me up. As well, I didn't wake me up. When I got here in June.
So she's lying when she says she tried a few times and then she taps your bed, kicks your bed a little bit.
That day, Miss Lower never telling me. And then in June, I got in a fight in my first time. The girl swung at me first.
Okay.
That's accurate what it says. Is right here with a closed fist.
Yeah. I mean, if you get hit first, that's not the one that I'm so worried about. It's the... Eating at your bunk when you're not... I mean, it's not even big stuff. It's just not following the rules. And if you can't follow the rules in jail, why should I believe that you can follow the rules on probation? When you're in jail, when you're on probation, when you've committed a felony, you don't get to make certain decisions for yourself anymore, right? Now, you're not going to be like every other 19-year-old and get to just do what you want when you want. You're going to have to do what either jail says or what I say or anything like that. If I'm going to follow this agreement based on the nature of the offense and based on the age and all of this, we're going to get you some help up front to be making better decisions. Otherwise, I'm not going to follow the agreement. Things could be a whole lot worse. Do you understand? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You're not going to get out of jail today. You're going to go to ISF instead, and you're going to hopefully pay attention and learn how to make better decisions. You're still young, you're still immature, but you're going to have to make some very mature decisions if you don't want to go to prison. And that's going to be to help you make those better decisions. Now, here's the thing. If you're in our jail and you start before they send you in the next week or two, or if you're in ISF and you are acting up and not following rules, put something on your head that you're not supposed to, eating where you're not supposed to or when you're not supposed to, talking about whatever it is, I don't care, then you could be revoked just for not following the instructions. And you'll never get out and even have an attempt at probation. Do you understand? So whatever's going on and whoever your buddies are in there, you need to tell them, just sit there, do everything you're supposed to do. All the playing around's done because you want to get out and make something of your life. And if they don't want to, that's going to be on them. If you keep doing all this, you're going to have a felony conviction and you're going to go to prison. It's that simple. You understand? The part of this probation that is so good is that you don't have a conviction right now. And if you're successful and you complete your probation, you are never going to be a convicted felon. So this is a great opportunity. But if you do violate in any way, you'll be back in here, you'll be a convicted felon, and you could go to prison anywhere in that range of punishment, which is between 2 and 10 years. All right. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Good luck to you. You go back with the bailiff. Spites. And Mr. Spites is charged with the offense of manslaughter in cause number 25, DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder, indicted for manslaughter. Intentionally and knowingly causing the death of an individual.
Let me look at the indictment. It shows, I don't know why the heading
Heading says manslaughter, but the language.
did then and there
intentionally
intentionally and knowingly cause the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first-degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at $800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ron James Spikes.
And Mr. Spikes, you're the person charged with the offense.
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
No, sir, I don't.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right?
Yes, sir.
And you've got some priors, but in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my
And-
wife, my family, and things.
Okay, and your family, and you have a job, were you able to make bond?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez,
Yes,
correct?
sir. Yes,
And
sir.
that's at 365 Scrap?
Yeah, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment
Yes, sir,
operator?
I do.
So you've always been working and all?
Yes, I have,
Do you
sir.
have any assets whatsoever? Real property, coin collections,
No,
anything
sir.
like that? Then you're asking the court to set some reasonable bond so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, he was sentenced 4 years GEC. So whatever if it's murder, he would be 15 to life at least. And if it's manslaughter, it's 5 to life. State court is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it is.
Okay. Let me take a look at this real quick. And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998 for 4-year sentence.
All right, 2 possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir,
Nah,
did you want to say that again louder?
I ain't saying that. I ain't saying that.
You did say something.
Well, I was like, well, I didn't say nothing to it.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right? Sir?
Yeah, I was like,
That's what it's set at right now. All right? You can go back with the bailiff.